The Patrick Cox ruling changes the rules on royalty taxation. Offshore apportionment is now a real opportunity. Redefine your tax strategy. Apportion income and unlock savings with the latest court ruling. Welcome to our latest tax insights. Today, we explore a landmark Court of Appeal decision that's reshaping Hong Kong's tax landscape. From royalty income apportionment to upfront payments, this case has major implications for businesses operating across borders. Let's dive into segment 1 and 3 of the ruling. In October 2024, the Court of Appeal issued a pivotal ruling in Patrick Cox Asia Limited versus Commissioner of Inland Revenue. The case focused on how income from trademark sub-licensing should be taxed. The income streams in question included a £500,000 upfront payment for granting sub-licensing rights and 16.7 million Hong Kong dollars in royalties earned from agreements with Japanese companies. The court upheld that the upfront payment was taxable in Hong Kong. This was based on the fact that the agreements generating this income were negotiated and signed locally, firmly linking the source of this income to Hong Kong. This reinforced the principle that the location of profit-producing activities determines the source of income, not the location of the payer. However, the court took a different approach to the royalty income. Earlier decisions classified all 16.7 million Hong Kong dollars as Hong Kong sourced, but the Court of Appeal disagreed. It noted that significant parts of the profit-producing activities, including marketing and contract management, occurred in Japan. The court ruled that the royalties should be apportioned between Hong Kong and offshore sources based on the activities contributing to the income. This landmark decision introduces a new dimension to how cross-border income is assessed in Hong Kong. This decision has far-reaching implications for businesses engaged in licensing or sub-licensing arrangements. It highlights the need to examine where profit-producing activities occur. The ruling emphasizes that the actual operations behind income generation, such as marketing, negotiations, and management, must be carefully documented to determine the correct tax treatment. For businesses with cross-border operations, this is an opportunity to claim offshore exemptions for income tied to activities performed outside Hong Kong. Apportionment allows you to reduce your tax exposure by demonstrating that not all profits are onshore sourced. However, achieving this requires meticulous documentation. Agreements must clearly outline the roles and responsibilities of each jurisdiction, and records must show the geographic breakdown of operations. Without this, taxpayers risk losing potential offshore claims or facing greater scrutiny from the Inland Revenue Department. This ruling also serves as a call to action for businesses managing intellectual property or international licensing arrangements. Now is the time to reassess your tax strategies and optimize your operations. By aligning your agreements and documentation with the court's emphasis on profit-producing activities, you can turn these new rules into a competitive advantage. Proactive planning will not only ensure compliance but also unlock potential savings. The Court of Appeal's decision is a turning point for Hong Kong businesses. With the introduction of income apportionment, companies now have a powerful tool to manage tax obligations across borders. Whether you're refining your tax strategy or exploring new exemptions, this is the time to act. Contact us today to navigate this new era of Hong Kong tax law. And don't forget to subscribe. Thank you.